Hi everyone, and thank you for joining today's session. Once again, we are here with Rose, our legal expert at Cloudi-Fi, and myself in order to explore the data privacy topic, this time in the United States, and how it applies to ISPs as well as the Wi-Fi regulations. Last month, we focused on European regulations, the requirements of GDPR, and how it applies to ISPs. If you are interested in this topic, of course, we can provide you the link in order to view the replay down below on the chat section. Contrary to conventional ideas, the United States does indeed have data privacy regulations. However, there is no one conventional, let's say, comprehensive federal law that governs data privacy in the country. There is a complex patchwork of sector-specific and medium-specific laws that address, for example, telecommunication and ISPs that we will explore today. First, we will start by discovering the similar aspects of European laws and the American ones. Then we'll deep dive into the data protection laws that are applied in the US, the rules that ISPs have to follow, as well as the penalties in case of non-compliance to these laws. At Cloudi-Fi, we are in the core of this topic, as we provide Guest WiFi for different industries in the US, and our solution is 100% cloud-based, and we can be deployed internationally. That being said, our particularity is that we are fully compliant with worldwide regulations, as well as the most specific ones in the US market. Now it is your turn to see and to make the best out of your business in the American market, and to see if the service that you provide is fully compliant. So, as previously mentioned in our last session, we have explored the European regulations such as GDPR. So now, can you tell us today what actually initiated the creation of data protection laws in the US?
Yes, and so 2019 Cisco reports revealed that since the adoption of the GDPR by the European Union, companies have won the confidence of their consumers, gain a competitive advantage, and there is also a reduction in data breaches and when they occur with less impact. So in the United States, California is the first state to follow the European Union example by adopting a law combining digital data protection and the breach of disclosure.
Okay, and can you tell us the difference between the GDPR and the CCPA?
Yeah, the CCPA and the GDPR are far from being identical. Indeed, the CCPA does not apply to small businesses, and it does not apply to companies that collect data from less than 50,000 consumers, earn less than 25 million per year, and generate less than 50% of their revenues from consumers' data. Also, the CCPA's fine only penalize companies for violation and not for compliance.
Okay. And on the other hand, what is the common relationship between European regulations and the American ones?
Yeah, in the United States, there are no restrictions on geographic transfer except for certain governmental information. But according to the European regulation, an operator subject to the GDPR can transfer personal information data of individuals only if the receiving state has an adequate level of protection. So there's two situations. First, if a company is located in the United States and wishes to process personal data of person located in the European Union, in this case, the company will have to comply with the GDPR. But if a company is located in the European Union and wishes to transfer that data that he's processing to another company located in the United States, in this case, the United States must provide an adequate level of protection. So if the European Commission considers that the level of protection is not adequate, then the transfer will be only possible if standard protection clauses are written into the contract. So we must specify that this statute of adequate level of protection is conferred by the European Commission, and it was the case for the United States until recently. The Court of Justice considered that the internal US regulation on data, and in particular on the access and the use of such data by the US public authorities, do not meet the requirement of the European Union law, and indeed consider that the exception to the principle of confidentiality do not mean the principle of strict necessity.
Okay, great. Thank you for the insights. Can you now give us a clear overview of data protection laws in the United States?
So in the United States, there is several sector-specific national privacy and data security laws. Indeed, for example, only for California, there is more than 25 privacy and data security law. So the first law was CCPA from California of 2018, which applies across sectors and imposes substantial requirement and restriction on the collection, the use, the deletion, and the disclosure of personal information. But after California, a number of other states are adopting privacy legislation. It is the case for Nevada with the Nevada Privacy Law, New York with the Shield Act, Texas, Washington, Rhode Island, and even Ohio with the Cybersecurity Act, which contain provision on data protection in particular in the event of data breaches. But with all this law, the problem is for business is that each state does not see the thing in the same way, and each federal state is adopting its own law and own provision. This can complicate the processing for businesses.
Okay, very interesting. As a big country, I believe that it is obvious that the implementation of data protection laws can be quite complex in the United States. Therefore, internet users should have their own rights, I believe. Can you tell us more about these?
Yeah, it appears that in the United States, most protective law is the Californian law, most protective of users' rights and personal data. So all these laws are guaranteeing rights to the users, and the most specific one is the right to opt out and opt in, and the requirement of online tracking notice. And for example, in California, businesses should include a "do not sell my personal information" link. So the principle is that a consumer should have the right at any time to direct a businesses and ask him to stop selling or sharing his personal information. But at the same time, in Nevada, companies doesn't have to include this link, but the law mandates that the company must provide a toll-free number, telephone number, an address, email, or a website to verify the request of opting out, for example.
Interesting. And what are the specific rights that exist, for example, for children or for minors?
Yeah, there's also laws adopted to specifically protect minors and their personal information. For example, we have the COPPA, the Children Online Privacy Protection Act, which applies to information collected from children under 13 years old, even automatically, for example, via cookies. So the primary goal of the COPPA is to place parents in the control over what information is collected from their young children online. That's why the text of the law requires a prior veritable parental consent to engage in such reversing and in such processing of personal information. But also the COPPA applies and covers operation only when the operator is aware about the age of the children, of the minors. So, and in the same time, this law doesn't require from operators to ask the age of the minor, of the person connected online. So, and we must specify that also in the CCPA, the California laws, prohibits a company to sell minor information when he is under 13 years old. But when the minor is under 13 and 16, he must himself affirmatively consent to the processing.
Great. We can notice that actually states take very seriously those different rights of different type of internet users, and that is very comforting indeed. On the other hand, can you tell us how companies that process data behave towards those different rights?
Yeah, the thing is, these laws guarantee right to users. So these rights are granted and protected, so their use cannot lead a company that processes personal data to adopt measures to sanction that use. So if a person wishes to exercise his right, for example, his right of opting out, a company cannot sanction that person and non-discriminated. So he cannot, for example, deny service to the consumers, charging or charge different prices or impose penalties to that user, or even provide a different level of quality of service to these users. And also the text mandates and say that the providers must make available to the consumers two or more indicated designated method for them to submit requests for information required to be disclosed, or requests for deletion, correction, included, for example, by installing a toll-free telephone number or an address email.
Great. So let's jump now to internet service providers. How do these laws actually apply to them in the United States?
So first, in the United States, the internet service provider are regulated by the FCC, so the Federal Communication Commission, and more specifically by the Part 15 of its rule. So the FCC does not regulate internet delivery service other than VoIP. So the FCC doesn't require from Wi-Fi providers other than the VoIP to apply for a license, authorization, or declaration of provision. So the Wi-Fi operates on the basis of unlicensed basis. But when the provider is a foreign company, the FCC will have to apply a public interest analysis in determining whether to allow a foreign investor to enter in the US telecommunication market. But we must specify that a government authority may ask to the internet provider to deliver and to disclose personal information that he holds about the users. And in the United States, except in limited circumstances such as emergency, laws prohibit a Wi-Fi supplier from disclosing such information to a government without a legal process. So there is two kinds of disclosure. The first one is a voluntary disclosure, which can be done by the user. But also the Cybersecurity Information Sharing Act also allows companies to voluntarily share certain kind of information without following this process, with this legal process regarding cybersecurity threats. And otherwise, if an investigator wants to compel the disclosure of this data, for example, the traffic data, he must use a court order or court issued and to warrant to obtain such information. And the type of court order necessary depends on the number of factors, and including whether the information will be intercepted in real time or whether it will be a previously stored information. So the statute differs also whether the consumer must be notified and given the opportunity to challenge the disclosure.
Okay. And what are the specific rules that Wi-Fi providers have to respect in order to be compliant with US laws?
First, there are no general retention requirements at this time in the US legislation. Wi-Fi suppliers are required to retain the record for 19 days, but only on the request of the government entities. And this information will be only information allowing to identify the consumers. So, for example, name, address, record of session time, date, duration of the connection, and the type of service utilized. Also telephone number, identity, any identity including temporary async network addresses. Also, we have a California law, the California Electronic Communication Privacy Act, which has some specific provision concerning the disclosure of electronic communication, electronic information, such as all the metadata, so the location data and IP addresses. So, investigator may also use another kind of law named pen register or track and trace device. So it can be used when the state attorney certified to the court that the information likely to be obtained by this installation will be useful on ongoing criminal investigation. But this installation cannot exceed a period of 60 days. But also, under a court order, other legal authorization, a Wi-Fi provider must be able to directly identify the person and the corresponding information, and that's why the Wi-Fi supplier must maintain and file the FCC System Security and Integrity Plan, which will detail how he ensures to the government an access to this data and how he will protect this data from unauthorized disclosure. But however, all these regulations do not mandate to the operator to install any particular technical standard to ensure law enforcement and for the access or the security.
Okay, so I believe if there are such rules, it means that there have been some data breaches before. Can you give us some examples of these cases, as well as the penalties in case of non-compliance of these laws in the US?
Yeah, in the US, unlike France, for example, all these disputes can be settled by the class action, and the class action will allow the companies and the users to find an agreement, and it was the case, for example, with the Anderson lawsuit. And in this lawsuit stems from a security incident where hackers accessed to Anderson, so it was a clothing retailer, a third-party e-commerce platform, and gain access to consumer personal information. So after that, all the hackers exfiltrated the information and used them for making fraudulent purchases by using the credit card of the consumer. So this case was settled with the class action. And also, under the California law, the CCPA that we talked about, this law provides individuals with a right of action on sanctuary damages. So. In the event of certain breaches, for example, when the businesses fail to implement reasonable data security provision, an individual can go to the court and ask some harm to the company. But at the opposite, the Nevada law doesn't provide any private right of action under this law. So instead, it's the enforcement authority is gained by the Attorney General, which when he has some reason to believe that the operator is violating the law, he can ask and institute a legal proceeding against the operator.
Thank you, Rose, once again for sharing with us actually your expertise about data protection laws, and this time with a special focus on the United States. Indeed, last month we saw that it is a matter that involves European countries, but now we can see actually that it is concerning all internet users in the world with different regulations adopted following the country. If you are interested in other regulation topic, you can of course, and you would like us to explore it, you can of course share it with us on the chat section, and we are open to any suggestions. You can also subscribe to our YouTube channel where you can check different topics that we cover, for example, business topics, including legal. The link will also be provided to you on the chat section. In the meantime, you can already register to our next month's session, which will be a bit different from this one, that will concern businesses as a whole and specifically how to secure your BYOD. In fact, with the current circumstances that we are all facing today, new habits have evolved in the business industry involving the behavior of employees, such as bringing their own devices at work. Therefore, we will see how companies can adapt to these new trends by ensuring security for their employees' connection journey. The link will also, of course, be provided to you on the chat section below. I hope to see you next month in our session, and now I am happy to answer all of your questions.